hearing in the Investec appeals.
Yes. I think it's Lord Goldsmith's probably going to speak first, is he? Can you hear us?
Yes. Yes, my lords, if your lordships can hear.
Yes, we
can hear you, but can your lordships hear me?
We can hear you, yes. And you're going to, am I right, has it been agreed that he should open? I think it is logical.
This was test. Thank you.
Right, you'll have to speak slowly. You're not coming through at the moment.
It's not been agreed, but it is logical. So unless there's any objection, I will do that.
Right.
No objection.
May I start? My lords, may I thank the court, first of all, for hearing me in this way. There was no other way that I could participate in this hearing. I understand there's quite a long time lag before my voice comes through, and I hope that is not going to be too inconvenient, but I'll speak as distinctly as I can. This is obviously in the context of the application that we have made to amend the notice of appeal, and your lordships will know the overall context of that. By a letter from your registrar, we were communicated 4 questions in particular coming from my Lord Mans. And if it's convenient, that's what I'm going to do, is to deal with those 4 questions.
Can we identify where the letter is?
So it's these 4 points.
Yes.
My lords, the first question
Yes.
if that's been done, my lord, I can't give your lordships a reference to where it is. Is it?
No, we have it. We have it.
Your lordships have it.
Yes.
The first question. Thank you. But that asks the question whether in the court below my clients sought a finding of gross negligence, or whether they only sought a retrial.
Yes.
The answer is that they very distinctly did seek a finding of gross negligence by the court. Indeed, that was the primary case, and the application for a retrial was the secondary case. Now, I can make that good in 2 or 3 ways. First of all, the notice of appeal, and your lordships have the notice of appeal in the second supplemental bundle at tab 7. And at paragraph 4, that identifies that we were asking the Court of Appeal to make an order that the former trustees do pay compensation to R&H as trustees of the TDT for breach of trust. My lords, the only way that the Court of Appeal could itself have made an order for compensation would have been if it had reversed the finding that the former trustees were not guilty of gross negligence, and had reversed it and substituted a finding that they were. Otherwise, an order for compensation could not have been made. Secondly, it's clear from the skeleton argument, but I'm going to go, if I may, to the transcripts of the hearing. The oral argument was quite complex on both sides. There was a substantial hearing, but a lot of the argument was directed to the issue of gross negligence and to whether there should be a reversal of the finding or a retrial. And I want to show the court that was the primary claim at the outset of the argument, throughout the argument, and in reply. So the argument, the claim that there should be a reversal of that finding and a substitution of that finding was never abandoned. It starts at day 1 of the transcript, which your lordships have at supplemental bundle 1 at page 495 in the hard bundle.
Sorry, you will have to give the bundle reference again.
Supplemental bundle.
Yes, for the preliminary hearing, tab.
That's it.
Tab 3, is it?
Yes.
And it's
Supplemental
page
bundle.
496
Thank you.
on the electronic.
Page, which 96?
496.
496.
3,
Electronic.
Yes, thank you.
tab 3,
Yes.
495 in the hard copy.
Yes.
In the hard copy, it's 495, and I'm referring to a paragraph which starts, in short, therefore, and this is Advocate Swan who is speaking. The overarching case presented on this appeal is that R&H did not receive a fair trial. My submissions on this appeal will have two objectives. Firstly, to seek to persuade you that on proper consideration of the available evidence, the weight of that evidence is so clearly in R&H's favour when correctly analysed against where the evidential burden fell, that undertaking the task which the Lieutenant Bailiff failed to carry out, or in the case of issue 3, wrongly carried out, this court can safely find in R&H's favour.
Yes,
So
we've read
the
it.
primary case.
We've read it.
Then he went on to say if you were to hesitate to undertake that task, because there's simply not a basis on the judge's reasoning or lack of it, in the judge safely to come to a decision on those issues. Thank you, my lord. Thank you, my lord. Could I take your lordships then to page 608 in that same tab in the hard copy? Sorry, in tab 4 it should be. That's the next day.
Yes.
Page 608. This is on the second day.
Yes.
There's a paragraph which starts, as I indicated at the very outset of my applications.
Yes.
Perhaps your lordships would read down to where he says, reasonably incurred, a few lines down.
Can someone tell me what the
So
electronic
two
number
legitimate
is?
approaches, and the first is exactly the same as the day before. And then on page 609, on the hard copy towards the bottom of that page, just to draw attention to this, if your lordships were reading more of this argument,
Yes.
Advocate Swan made it plain that there were two issues to which this went: whether or not liabilities were reasonably incurred and whether there was gross negligence, and he wasn't going to repeat both each time, but his references should be taken as being to both.
Yes.
At page 617,
I mean, does he need, do you need to go through all these? If you made your point. We don't,
having dealt with the reversal of the finding, let me just give, if I may, I think I've made my point, may I give two short references? One is at tab 4 at page 761, where he's actually asked by the court whether he's inviting a reversal of the finding. That's at page 761 of the hard copy.
Could someone give me the...
I will, when I...
767.
Thank you.
And there's a reference saying a member of the bench asked this question.
You have to add 6 throughout, do you?
No. It's 3 to the first bundle, 6 in the second.
I'm grateful.
So what are we looking at here?
Advocate Swan, yes.
Yeah. Thank you.
We're looking at where Miss Advocate Swan is asked. Advocate Swan is being asked by somebody, clear from the bench, whether or not they should, if they agree with him, not order a retrial, but actually substitute a finding.
Yes. Right.
And on page 763,
He says...
bottom in the hard copy, if your lordships read that, you can see Advocate Swan is still saying, well, decide it yourselves if you can. And then the final reference is a page, and I'm going to skip out some other references, at page 988, that's in tab 6, isn't it? That's in tab 6. So this is now the final day.
So how much do we add?
994
994.
in the red line. Electronic.
So at 985, someone can help your lordships with the electronic bundle version for that. 985.
991.
Thank you.
Well, a fair reading, I don't want to take up time, really saying that if Advocate Wessels has persuaded the court that they can't actually make those findings, then it would be appropriate to order a retrial. But that illustrates that this is a secondary, that the primary case was reversal of findings. It's at page 988, towards the bottom of the page in the hard copy, against the reference to Mr. Ian Swan. So, my lords, I think I will stop there in relation to the first question, because that adequately shows in our submission that this was the case that was argued. It was argued strenuously, never abandoned, repeated right the way through to the end of the submissions.
Right. The second question.
And if your lordships are happy with my now going on to the second question.
Right. Same material or not? Yes.
The second question is whether or not this issue involves the same material as the retrial material or additional material. Yes, exactly. Our submission is it's the same material. There may be some minor differences, but not in our submission significant. There's obvious reasons why it is the same material. Firstly, because the same material will be relied upon on the retrial application in impeaching the conclusions of the Lieutenant Bailiff and of the Court of Appeal. And we're really talking not about whether their findings are impeachable, but what the remedy should be if this court should agree with us. Should that then lead to reversal of the findings and substitution of different findings or a retrial? The second reason is because, and we've seen it referred to already, this overlap between the questions of gross negligence and whether liabilities were reasonably incurred. They apply, of course, in respect of different provisions, but the way they were treated below and in our submission, understandably, is that they are largely the same question, though differently expressed. So the same issues that arise on the gross negligence question will be argued in relation to the reasonably incurred question. There are, as I've suggested, perhaps a couple of differences, but interestingly, they've been, my learned friends have set out in their notice of objection some facts which they say arise on the gross negligence appeal, but not otherwise. And there are only two of those which could conceivably be said not to arise, and that relates to an allegation allegations that they relied upon R20 or on another firm. Those are not substantive questions in our respective submission. Any reason to treat these as important points, and as illustration of that, neither of those points actually appears in the written case that's been put forward, which gives a strong indication as to how significant they actually are. They've come forward for the purpose of seeking to resist this application. So it's essentially the same material that the court will need to look at for those two other issues as for this, if your lordships grant permission.
Can you identify the two minor points which appear in the notice of objection but do not appear in the written cases?
Yes, my lord, let me just take that turn. Your lordships have it in the application bundle, tab 4.
Yes.
At paragraph 14, paragraphs 14.3 and 14.4. We respectfully say those are actually very, very weak points in any event, and the fact that they weren't relied upon in the written case indicates how insignificant they are, but they're minor issues. Obviously, if your lordships disagreed at the end of the day and thought that there needed to be a further examination of those issues, then the right order, we would say then, would be the retrial. And the Court of Appeal below looked at all of the material that's relevant to those questions. If I may, my lords, the third question is whether oral submissions would be required. For my lords, your lordships will know that our view had been, and that your lordships would actually be assisted by oral submissions on a number of these questions. Your lordships have considered those submissions and not accepted them, and I don't, of course, seek to go behind that. We do not see that allowing this additional amendment changes that analysis. In other words, we would still have liked and respectfully think that the court would have been assisted by oral submissions, but allowing or not allowing this amendment makes no difference in our submission to that decision.
Could you? I think we may want to hear your opponent on this question, but I haven't at the moment got a view as to what the time is really going to be occupied by, and I certainly don't, I think the original order did not preclude reconsideration of this aspect if it was necessary, But at the moment you're saying that it's not necessary, but it's a point which we might wish anyway to consider. Right?
Well, my Lord, yes. I think to be completely accurate, we think it's desirable, but not necessary.
Yes.
The final question did ask whether we thought this was still doable within the hearing dates. And that ties in with the observation my Lord Mans has just made. The current position is that we've got 3 days with 1 in reserve available. The division of that hasn't yet been agreed. Our position is that we think that's ample in order to deal with this additional point as well. As to what the majority of the time will be taken up on, a lot of it will presumably be taken up on the Section 32 question, but that is in large part a question of construction and technical, and it's questionable how much time will be taken up with that orally, but I haven't discussed this with my learned friends, so I don't know what they think about that. But in any event, our position is, in short, on these questions, this all has been dealt with before. It doesn't add anything significant, and it can be dealt with on the existing timetable. And as a matter of justice, given the significance of the issues, we do respectfully invite the court to allow this amendment. My Lord, I was going to stop at this point, unless there's any other issues that your Lordship wants me to deal with now, though I appreciate, having heard my opponents, there may be some issues I want to come back on. There are certainly issues they raise in their notices of objection, which we disagree with quite strongly.
Thank you. No, we are grateful for the brevity, and we will ask your opponents to address us. I imagine it's unnecessary to call on your junior, I imagine. But I'll call on Mr. Taube.
May it please, Your Lordship. On the first question, the position is that by the time of the reply, R&H had effectively abandoned their application for substitution of new findings of fact and were pinning everything on the hope of getting a retrial. You find that if you go to tab 6 in the supplemental bundle starting at 918. I'm not going to go through it all. Can I come back to it in a minute and just explain to you why the R&H had adopted that position? They argued in relation to a retrial that the reason why it was necessary was because the judge had not engaged with the facts. They said, however, that the Guernsey Court of Appeal could not look at facts outside the trial judge's judgment to see if there was a factual basis outside the judgment to support his findings of fact that he did make. The former Trustees Council took the Guernsey Court of Appeal to evidence both covered in the judgment and outside it during a day's submissions on day 3 of the hearing. And he showed that there was ample evidence both within the confines of what was mentioned and outside it that supported the judge's key findings on gross negligence, which were found between paragraphs 234 and 251 of his judgment. And the essence of the position that R&H adopted on this was that the facts were all so complicated and, as they put it, the issues in this case are far too closely interwoven for it to be remotely feasible, or indeed fair, to a new judge to approach them with certain aspects already decided. That was in response to a submission to whether, or a question whether or not one could hive off some of the facts or not. So their case was that it was all, the issues were so closely interwoven, it wasn't remotely feasible to deal with just some of them. And therefore, they said, the Guernsey Court of Appeal should not look at all the evidence. It was wrong on a 2.5-day hearing of the appeal in relation to the findings of gross negligence to go into all those facts. So it was, in the light of those submissions, impossible for them by the time of their reply to say, nevertheless, we are going to ask you to make findings on certain facts and reverse those of the trial judge. That would have been logically inconsistent with the way they put their case on a retrial. And they made a decision to ask the Court of Appeal to order a retrial. And that appears, as I say, from the reply. And I'll show you the relevant passage. Can I just contest the proposition whether that's the right analysis of what happened or not, with two points. First of all, if one looks at the Guernsey Court of Appeal's judgment, they understood that what they were being asked to decide was whether or not there should be an order for a retrial. And one finds that in the Court of Appeal's judgment, the retrial judgment of August 2015, at paragraphs 29 and 97. And they are in volume 1, it's tab 11, page 321 in the electronic bundle, and 339. If I go to 321 first, it's the final sentences of paragraph 29 of the Court of Appeal's judgment.
Yes, it was that sentence that prompted the question, I think, in large measure.
And you'll see there's another reference to it. The present trustee submits that if the complaint of excessive delay is made out, then the Court of Appeal should remit the cause back to first instance for a retrial. It is said that it would not be appropriate to remit back to the Lieutenant Bailiff for him to articulate his reasons because of the length of time which has now passed since the trial. So that was one.
Yes, and 97.
97
yes.
is to the same effect.
Yes.
We have set out at some length our consideration of the... Sorry, this is page 339 in the electronic bundle, Manuel Carmarth. We have set out at some length our considerations of the issues which were presented to us under this head of appeal of the present trustees. So this is when they're dealing with all the factual issues. In part, we have done this in response to the exhortations on behalf of the present trustee, that's R&H, that only a detailed understanding of the case and the judgment would show the deficiencies in the process of the judgment and lead to the conclusion that only a retrial would suffice. In part, also we have done so because the issues were so widely canvassed before us. So that was what the Guernsey Court of Appeal understood was the issue before them. There is no suggestion, if one looks at the rest of the judgment, that the primary case, as Manuel Goldsmith puts it, was that there should be a substitution of findings of gross negligence. And the other way one can test the proposition is by looking at the notice of appeal. And the original notice of appeal complained about the failure of the Guernsey Court of Appeal to order a retrial. It didn't anywhere state that the Guernsey Court of Appeal had failed to address the arguments of R&H that the findings of the trial judge should be reversed and substituted findings should be made. And if it really was the case that R&H, in their reply, had been seeking substitution of new findings of fact, one would have expected that to be their principal ground of complaint in the notice of appeal to the board. But there is no complaint about that. Instead, the complaint, if one looks carefully at the way it's put on what they call the retrial appeal, the clue is in the name. On the retrial appeal, they're simply saying the Guernsey Court of Appeal was wrong because they failed to order a retrial. Can I come back then to the transcript? I'm not going to read all of it, but the key section, which I would invite your lordships to look at if you have an opportunity afterwards, is in Supplemental Bundle, Volume 6, and it's Day 4, which deals with Advocate Swan's reply on behalf of R&H. And we submit that on a fair reading of that, taken as a whole, it goes from, in the electronic bundle, from 919 to 997. On a fair reading of that, it's clear that Advocate Swan was trying to persuade the Guernsey Court of Appeal to order a retrial, and he was trying to do it on the basis that the Guernsey Court of Appeal couldn't, on a 2-day hearing, or 2.5-day hearing of this kind, look at all the evidence and satisfy itself that the judgment was safe. And Advocate Swan complained about the approach of the former trustees in looking at evidence outside the trial judge's judgment to show that the trial judge's findings, crucial findings, could be supported. He said that was not a permissible approach. And in those circumstances, it was just impossible for him to run at the same time an argument that the Court of Appeal should look at all the evidence and reverse the findings.
Can I interrupt? You just referred us to pages 918 or 9 up to where?
It's 997, 998, where Advocate Wessels, who was for the former trustees, had a short response because there were new points raised. So one finds that Advocate Swan's advocacy in reply goes from 919 to halfway down 998, my lord.
You're not asking us to read 80 pages.
I'm not going to do it, no. I'm just telling you that's where it
can't
is.
Can't you show us the high point?
I will, yes.
The best nugget?
I will, yes.
Well, I mean, the nugget, I think, that you're proposing is the assertion that the court couldn't look at all the evidence.
Yes.
Because that is the one that would contradict the assertion
Yes,
that
exactly.
you
Where's
substitute findings. Where do we find that? Yes.
If I may, can I show you? I'll just give you the nuggets, and I think it's in one of those. It's 920. Is Advocate Swan in reply describing what Advocate Wessels was doing? He said, first paragraph right at the end, his approach was clear. He in effect invites the court to embark upon the very tree.
No, just pause. You say 920 confidently. I'm using the hard copy.
I'm sorry, 914.
914, right. Yes, right.
Okay.
Yep.
So, sorry, my lord. Yep. So, that's Advocate Wessels for the former trustee, invites the court to embark upon the very retrial which, in my submission, can only be undertaken by a court of first instance to which this matter should be remitted. Going on to 921, halfway down, can you see from the judgment, 921 in the red, 915 in Lord Mance's hard copy. From the judgment, what we can deduce that there is an almost total failure to engage with the evidence. Applying that principle, that the losing party ought to be able to deduce from the judgment why it has lost and why procedural irregularity constitutes a freestanding ground of appeal. I cannot say, will the judge prefer this witness to that witness? And because of that issue, it would be wholly inappropriate for this court to delve into the facts, because I do not know what he did. But that cannot be a bar to the argument that, nonetheless, the proper forum for that type of delving into the evidence must be a court of first instance. And then he goes on, at page 916 in the hard bundle, 922 in the electronic. So, sir, I say that on Advocate Wessel's own approach to this appeal, it is abundantly clear that the only proper solution is a retrial. He talks about the trial.
Sorry, where was that again?
Sorry.
916.
916 in the hard.
First full paragraph.
So, sir.
Yeah, no, I have it. Yeah,
I say that Advocate Wessel's own approach.
yeah.
Clear the only proper solution is a retrial. And then he explains what Advocate Wessel's submissions had been as he characterised them. And then he says on page 917 in the hard, 923 in the electronic, fourth, as I hope to demonstrate, yesterday's survey of the evidence left wide uncharted territory. So that was the survey by Advocate Wessels for the former trustees, which this court cannot feasibly or properly evaluate. And in making good that submission, I'd be taking to a small number of islands in the archipelago myself. But the individual controversies to which those relate are not really the point. The point is that this case was decided at first instance over the course of a 12-day trial with copious documentary material, days and days of live evidence, and then 12 days it emerges. And then over the page, 918, in the hard, 924 in the electronic. Do your lordship see, and so my submission was. And so my submission was that the deficiencies in the resolution of the matter cannot be remedied by just over 2 days of appeal proceedings. And Advocate Wessels had said the claim by RNH was doomed to failure. I accept that he has correctly characterised the test which he means to satisfy. I mean, he invited you to rule the conclusion that Calthorpe would not have consented was, in his words, the only answer which the Lieutenant Bailey could have arrived at. And applying that test, and that was a key issue on which the Lieutenant Bailiff had decided the entire trial. I submit there's no possible way in which this court can be satisfied to that degree of certainty, having not had the advantage of actually trying the case. And it goes on at the end of that paragraph, and that is something which only another judge, properly hearing the matter and properly giving a recent judgment, can deal with. The complaint was the delay.
The page you're reading from?
919.
919, thank you. Yes.
925.
Thank you.
And so I submit, he says, that Advocate Wessels is wrong to contend that our case on causation was so patently defective this court can safely uphold the judgment. So those were the nuggets early on. My lords, then going forward, the ones I wanted to refer to were at, sorry, I think it's 9. It's 937 in the hard copy, 943 electronic. And there was a question about what had to be established when one was alleging lack of reasonable care and whether or not it would have caused loss. And at the bottom of page 937, hard copy, page 943, electronic. My submission, says Advocate Swan, is that that simply cannot be made good by a whistle-top tour of certain highlights of the evidence. If the judge failed to analyse the case properly, the case that I say was pleaded, was put to witness, was developed to him in the passage of closing for which he simply failed to engage with, then the case has to go back for retrial with the issues properly. And then the final nuggets that I wanted to refer to come at the end of his submissions. It's 988 to 990 in the hard copy. It's electronic 994, my Lord.
Oh, so it's 988
988 to 990.
988, yeah, right.
He was dealing with the suggestion that a lot of the case that R&H were trying to advance had not been put to the witnesses, pleaded, and he says, it was pleaded, it was put, and the judge recognised this, but he simply didn't deal with it. In short, there's simply no warrant for the approach that the other parties invite you to take in this case. If Advocate Wessel's forensic analysis has persuaded that you cannot reverse the Lieutenant Bailiff's findings to the extent that you can find for Rawlinson and Hunter, so be it. So that's the only reference in the whole of the reply to the idea of substituting findings.
But isn't that the sort of submission that counsel might well make in circumstances where he can see the way the court has gone and he doesn't abandon his original case, but he realistically focuses on what he thinks might appeal to the court? Can you really say he's given up the case of gross negligence?
My Lord, I would say that he hadn't hauled up a white flag and said, we give up, but he had done nothing to try to sustain it in his reply. There is nothing in the reply which seeks to sustain that case.
Of more significance, it might be said the case against Advocate Wessels was contrary to the suggestion that one could make a ruling but by having an overview of the archipelago.
Yeah.
Well, Advocate Wessel's case was indeed that there was no possibility of running a case on gross negligence. It was simply had to be dealt with as to whether or not the judgment of the trial judge was safe.
Yes.
And that's what he was effectively dealing with, and seeking to persuade the Guernsey Court of Appeal that the trial judge's judgment was safe, in spite of the 18-month delay.
I think my Lord's point is a slightly different one, that he was countering Advocate Wessel's invitation to stand by the first instance judgment by saying, look, there are errors in it and there's so many other facts that you can only really form a view by a retrial.
Yes, it was the contradiction between that stance and the rather tepid preservation of the principal case.
Advocate Wessels, who presented it alongside me, and I think he would endorse what you're saying.
Yeah. Right.
And just finishing off the 995 and 996, can I just take you to this? If there is to be a retrial, then inevitably in a case like this, it will have to be a retrial of all the issues. The issues in this case are far too closely interwoven for it to be remotely feasible or indeed fair to a new judge to approach them, with certain aspects already decided, with one hand tied up behind his back and so on. But it's the point that the issues were recognised to be so closely interwoven that it wasn't appropriate to substitute findings of fact in a case of such complexity. And over the page, 990, that's 996, my Lord Carnworth, in the electronic bundle, Mr. Swan, Advocate Swan said, on the facts across the whole spectrum of the case, one simply cannot try and take part of it out. Everything is bound up with everything else. In any event, we say that the whole of the Lieutenant Bailiff's judgment is ineffective by the inadequacies of his approach. So we say that if that was the thrust of his case, and it was ultimately the case that he asked the Court of Appeal to decide, it was impossible for him at the same time to be submitting that the Court of Appeal should be substituting its own findings of gross negligence, and that's why he just didn't ask them to do that in the 77 pages of reply. My Lord, that's what I have to say on the first question that the Court has raised. The second question is what...
Doesn't it deal with much of the second question as well?
Well, Your Lordship asked what additional material will have to be considered. And if there was an attempt by the R&H to substitute findings of gross negligence, and my Lord Goldsmith said that there were only a couple of minor matters which would have to be looked at. And with the greatest respect, that's not an accurate characterization of the matter at all. During the trial, the former trustees had three defences which really aren't dealt with in the judgment of the Guernsey Court of Appeal or the trial judge, because they didn't need to be as a result of the failure of R&H to establish that there was something that the former trustees could have done to discharge liabilities which it was found that they had properly incurred. And in particular, one needs to understand a little bit about how the structure worked here. The former trustees based in Guernsey, they had a series of subsidiary companies which dealt in public equity holdings and contracts for differences in London. And they had margin accounts and very large borrowings. The former trustees acted at all times on the recommendations of a company called R20 in London. And R20's duties were to advise not merely on investments, but also banking arrangements of the former trustees and their subsidiaries. This was all pleaded. And the former trustees' defence was that they entered into the framework agreement, which is the source of criticism, on the advice, indeed at the urging of R20, who were their investment advisors, and that was neither negligent nor grossly negligent. R20 was the investment company of whose chief executive was the principal beneficiary of this trust. So it was a strong defence on their part of the former trustees. And moreover, the matters of which R&H claimed that something had gone wrong were matters which the former trustees contended were well known to R20, the investment advisors. So if a finding of gross negligence is going to be made against the former trustees in this case, it's necessary to deal with that fundamental defence, which is not covered in the judgment of the Lieutenant Bailiff. It's not adverted to, in the Guernsey Court of Appeals judgment because it didn't need to be. Because there were no findings by the Lieutenant Bailiff on the subject, so there was no need to analyse whether or not his judgment was safe on that point. It just hadn't been dealt with. At the trial, a great deal of evidence and cross-examination was directed to that very issue.
But basically the defence is you knew precisely what we were doing and you recommended it effectively.
And you acted on advice from investment advisors.
And we were urged to do
Who were
it by...
Yeah.
It wasn't just...
R20 is the people who are complaining effectively.
And it goes further than that. The man who's complaining, Mr. Cengiz, had given a personal guarantee of his liabilities, of the liabilities of the former trustees to Kaupthing. Kaupthing could at any moment in December 2007 have sold everything and exercised their rights as mortgagees or chargees. And in addition, they could have enforced the personal guarantee against Robert Cengiz, the chief executive of the investment advisors. And so it was a defence of considerable potency.
Yes, I'm not sure that I've got the picture in my mind where Kaupthing fits in.
Could I clarify?
Well, we mustn't spend too long, but yes.
It was the provider of the non-recourse loans which funded the transactions.
In December 2007, this whole structure was dependent on finance from Kaupthing. There was an outstanding facility which of 122 million odd. The former trustees had originally obtained the facility, and the idea was that a subsidiary should take over the borrowing and get 370 million from Kaupthing. And part of the deal was that Mr. Cengiz's personal guarantee of the former trustees' liability to Kaupthing disappeared.
Yes, quite.
And so R20, the investment advisors, were saying this has got to be done quickly. That's why the judge said there was urgency.
Right.
And as a consequence, there wasn't time for a great deal of shilly-shallying. The whole structure could have tumbled down and Mr. Cengiz would have found himself personally liable for his guarantee. So that's the first defence, which isn't touched on.
Right.
The other is that the former trustees instructed also a leading firm of London solicitors called Kirkland Ellis, who advised on the documents which gave effect to the relevant transactions under which the former trustees' liability was replaced by a liability of its subsidiary.
Who do they instruct, you say?
Kirkland and Ellis.
Yes,
You probably know the American.
I do, yes.
Yeah. And they were advising on the terms of the transactions. And the complaint by R&H, one of the complaints is that the transaction documents left liabilities of the former trustees to subsidiaries ongoing. One was called Glenalla and another was called Thorson. But the defence pleaded again, was that R20 and Kirkland and Ellis, who were responsible for putting the transaction together, were well aware of this. Again, it's not dealt with in the judgment, but it's one of those things which your lordships would have to consider if you were going to substitute a finding of gross negligence on the part of the former trustees, because they're acting on advice from a leading firm of banking solicitors, as well as R20.
So you say basically these were the factors which led Advocate Swan eventually effectively to accept that It was a retrial or nothing.
He had no choice, my lord.
Right?
There are other issues which it's fair to say in our written case we've touched on en passant. We haven't developed at all. All we've done is point out that there were other defences which the Guernsey Court of Appeal was aware of, which were referred to in the former trustees' skeleton arguments, and which were discussed in the, one can see them in the transcript. And they are also, when you come to see the written case, created formidable difficulties in the way of sorting out these problems. And not least, what was really being suggested by R&H at trial was that, so far as we could see, that the former trustees should have procured that their underlying companies committed breaches of their duties under the insolvency legislation, the BVI. The judge was well aware of that, the trial judge. He made the point to Advocate Swan, how could any of this have been sorted out if the trustees and directors had been performing their duties? It couldn't. And we've referred to that again in our written case.
Can I ask, these points, you accept if there was a retrial, they would have to be investigated there, and why do you say they can't be investigated here? Because for the same reasons that were argued in the Court of Appeal, that these are simply, it would be too complex an exercise for an appellate court to undertake.
I would defy this court to do it in 3 days. It took 12 days. It is a complicated story.
Yeah.
What about the point that Lord Guernsey makes that we're dealing with unreasonableness, and in practice gross negligence and unreasonableness was all treated as two sides of the same coin, so that if we've got to deal with unreasonableness, then what does it add if we have to deal with gross negligence?
Well, my lord, there is no appeal on the factual question whether or not there was unreasonableness outside the scope of the retrial appeal. What they're trying to do is to bring it in as an issue of fact.
What do you mean? So far as unreasonableness is concerned, that was also argued on the basis that it could only be addressed by a retrial.
Well, my lord, it's very difficult to know what they were arguing on that. But what they said was that at an early stage on day one, whenever we refer to gross negligence, you should understand us to mean unreasonableness too.
I think they said vice versa.
Oh, something like that, yeah.
Yes.
So
you say by the end they were really saying it's a retrial or nothing for all these factual or evaluative judgment issues.
Yes.
Right.
My lord, there is a further problem about the way that R&H are trying to run this appeal, which is that they are asking the Privy Council to substitute a finding of fact on a matter which they never pleaded and on which there was no evidence directed specifically to the issue, and on which there was no cross-examination. And it is, if one looks at their written case, absolutely fundamental to the way they put their claim to the Privy Council.
And what is that finding of fact?
The judge said that in order to sort out to discharge the liabilities that the former trustees owned to Glenalla and Thorson, that would have required the consent of Kaupthing Bank as a result of the contractual documents. The judge decided that there was no reason to think that Kaupthing would give up the additional security which these covenants from the former trustees gave them. And indeed, we wouldn't be here if the Kautzing Resolution Committee, represented by my friend Quater, who ultimately have instructed the liquidators of these companies, weren't seeking to enforce these liabilities owed by Glenalla and Thorson and Oscatello to the former trustees. But the case of R&H is, oh, well, Kautzing would have consented. And they had a very elaborate argument, which they articulated, not, as I say, in pleading or in course of evidence, that it would somehow or other have been in Kautzing's best interests to have agreed to a complicated restructuring of the TDT companies, under which the former trustees' liability to Glenalla and Thorson would be replaced by a liability of Oscatello, not the former trustees, the Oscatello company. And they had a very complicated argument about how, well, this would all have been somehow or other in the best interests of Kautzing to have let this happen. Now, in the first place, the evidence, such evidence as we did have, is that Kautzing was Oscatello, the intended new debtor, was probably insolvent by the beginning of 2008. More particularly, there were various other companies in the TDT structure which, although they looked as though they had balance sheet value, because their underlying assets were things like public equity holdings, very large ones in public companies, and contracts for differences, actually, their assets weren't what they appeared on the balance sheet. And that is an issue which would have to be resolved. What was the real value of those companies in the structure? And it wasn't before the trial judge, and the evidence didn't deal with it because it was not pleaded.
Well, that may be an easy route to success on it if it arises, but may or may not be. I'm not sure that it can necessarily add much time or difficulty to the matter, but it's a separate point anyway. It's a third problem.
As I made clear, that's right.
Yeah.
That's right. So,
right, now where do we go? Because you're taking more
I'm sorry.
time than has been allowed.
I think the only other question is what knock-on effect it would have for the hearing at the end of November. Could I just give you an idea of what the other issues are about,
Yeah.
and why, in our submission, they're likely to take all the time that you need, or will take everyone a great deal of time, because they are genuinely difficult issues. The two substantive issues concern a serious issue of private international law which has never been decided before. And it's of not just importance to the Channel Islands, it also is relevant for wherever you have a trust governed by states in the US, where a trustee enters into a contract as trustee. And the issue is, does the governing law of the trust, which may create the equivalent of limited liability, prevail when a third party knows he's dealing with a trustee? Or does the proper law of the contract prevail? And that's the argument which is going to take place. It's never been resolved at common law, and it raises fairly serious issues, not just, as I say, for the Channel Islands, but also for...
What are the respective cases on that? You say
the case
law of the trust.
We say the law of trust prevails, and that flows from the rules both in Jersey and Guernsey dealing with how you deal with foreign trusts.
You can walk around with a sort of general protective aura.
Like a company, my lord.
Like something out of Star Wars, isn't it?
Good. And the argument for learned friend is that the proper law of the contract governs
Yes.
all the issues, but it raises.
Well, it's obviously interesting, and I've never heard of it as before, and you're right, it's novel to me. Yeah.
And it will require serious debate in my respect. The second issue is my learned friend is relying on a claim, he's putting on appeal a claim in unjust enrichment, in which he's seeking to rely on the principle of free acceptance.
Yes. Well,
And as your lordship, I'm sure, is aware, there isn't actually a decision where free acceptance as an unjust factor has enabled a claimant to succeed. There is some academic arguments. There's quite a lot of learning to deal with in that context. It's again.
Didn't we come close to saying that it succeeded in Coys of Kensington?
My lord.
Perhaps not. Anyway,
that's one of the questions that
yeah.
and that is again.
Anyway, it's not a Supreme Court authority.
My lord,
But in any event, I mean, the Channel Islands are a civil law jurisdiction, and is the English law of unjust factors part of the law of the Channel Islands? It certainly isn't in most other civilian systems which have unjustified enrichment.
well, my lord, yes, we're still grappling with
Well,
that issue.
Telling us their difficult
Yes.
issues with
The answer is we're quite right. We shouldn't get too excited about the meat of this case.
But
anyway, we've got the point.
it adds to the point that there is the unjust enrichment issue is a big one.
Can I just be clear? I mean, going back to the point I was putting to you, if we go to the amended notice of appeal, which is what we're talking about, which is paragraph 40, page 40 of the amendment application bundle, which I have in a hard
Could you give
copy.
the electronic number, because I have that?
I'm afraid one of your many assistants will have to do that. I've got it at page 40 of this useful mini bundle.
The amendment application.
Yes,
Yep.
and it's a notice of appeal, which is what I thought we were arguing about,
Right.
and the amendments to that. Is that right? Is that not what we're arguing about? I mean, I may be...
I'm sorry, I'm struggling to find the document that your lordship's referring to.
Well, aren't we arguing about an amended notice of appeal?
Well, I thought it was tab 8 or 7, 8 or 9.
8 and 9 are where the amended notices of appeal are.
Yeah.
And it's, in the electronic bundle, it's 214
Yes.
onwards.
Well, what I'm looking for is what allegations we've got to deal with anyway of unreasonableness, and to what extent the allegations of gross negligence overlap with them. Yes, I mean, on 2.1.12, I think it's the same document, in fact, the failed to, page 224, paragraph 2.1.12.
Yes. Right.
As a result of its conclusion, the Court of Appeal held and so on. In consequence, they failed to deal with that part of the appeal directed against the judge's conclusion that they had failed to divest themselves where fact liabilities unreasonably incurred. So there we have the issue of were they unreasonably incurred in play. And then what the amendments do is to seek to bring in the question of whether they amounted to gross negligence. Are you with me or not?
I found your, yes, and I...
Well, I mean, this is what I thought we were arguing about.
If your lordship goes back to 3 pages,
Yes.
this is the grounds of appeal on the construction of Article 32, which is a question of law.
But I understand that. But are we not concerned with whether the Court of Appeal should have found that liabilities were unreasonably incurred? Or reached a conclusion on that?
Well, as I pointed out earlier, Advocate Swan said one treated them as substantial. Do you remember he said that...
He said 2 times the same coin.
Yeah, but what we're dealing about is whether whether the existing notice of appeal doesn't already cover the same
This is
subject
the point.
matter.
This is the thing that concerns me, is whether we aren't going to be digging around, like it or not, in all these issues in order to decide whether there's been unreasonable incurring. and whether it actually adds anything to start saying, well, is that not just merely unreasonable, but actually gross negligence?
My Lord, can I explain how the issue went before? Because they are actually, there are two separate questions. Article 26(2) of the Jersey Trust law says that it deals with the relation between trustee and beneficiary, and it says that a trustee is entitled to be indemnified out of the trust property where a liability has been reasonably incurred.
It's set out on page 222, Article 26(2). Yeah.
Thank you.
I understand that.
Exactly. There were three claims of gross negligence. One was that the former trustees had incurred liabilities to Glenalla and Thorson. It was found that that was not unreasonable.
Yeah.
Now, that appeal, although there's complaint about it in the notice of appeal, if one looks at the written case, that element has been dropped in the written case. One finds that paragraph...
So that's that point.
No, which paragraph, which?
It's in, the written case is at tab 10.
And it's dropped at?
And paragraph 22. It's 261 in the electronic bundle, 258, Lord Mance.
Yeah, thank you.
Yours. I know.
Yes.
So, what the trial judge decided, and this was not challenged, was that the original incurring those liabilities under the deed of novation was reasonable. The R&H tried to argue that the subsequent failure to divest the former trustees of a liability that was properly incurred meant that they somehow failed to come with an Article 26(2). And the trial judge said, no, that's not right as a matter of construction. These liabilities were properly incurred. And your complaint about the failure subsequently to divest the liabilities is a matter which you have to succeed in gross negligence or not at all. Yeah. And so going back to their notice of appeal, they're making a legal point about how one construes, sorry, that's page 224 in the hard copy, 227.
Did he accept, though, the trial judge, that there was negligence in failing to divest themselves of those liabilities?
No, he did not, Lord. And
so there is a factual question as well as a legal one, is there?
My Lord, yes. The whole premise of the written case is that there were supposed to be findings of negligence by the trial judge. That was put to the Guernsey Court of Appeal, and they said, no, that's not right. And if one looks at the trial judge's judgment at paragraphs 234 to 251, he was only dealing with the issue of whether or not it could be shown that grossly negligent breach of trust had occurred in the failure by the former trustees to divest themselves of liability. He made no finding of negligence.
It's just looking at the page 224, do we see that, ignoring the blue, the amendment, where it says, the Court of Appeal failed to deal with this part of the appeal, directed against the conclusion that liabilities of which the trustees had failed to divest themselves were unreasonably incurred. Further, given the trial judge's findings that the former trustees fell short of the anticipated high standards, the liabilities were thus unreasonably incurred. In other words, they're not seeking to expand or ask for further findings of fact. They're just simply saying there's one already there, and you say it isn't there.
Exactly.
Yeah. You say when you read it in context, it's actually not a finding of negligence of any sort.
Exactly, my Lord.
Yes. Yes. Right, so you told us that there are... does that answer the question?
Well, up to a point.
Yeah. So you told us there are two legal issues. Is there anything more you want to say?
Can I tell you how long each issue took in the Court of Appeal
Right,
to argue,
yes.
just to give you an idea?
Yes.
There were, because of applications to adjourn by R&H,
Yes.
the hearing, in fact, didn't take place on one day, but on one occasion it took place on 3 or 4 occasions. But the question about whether Article 32, the private international law question, whether it applied, that took 3 days in the Court of Appeal. There was a further day in the Court of Appeal on how you interpret Article 32 as a matter of statutory construction. In February 2015, this retrial appeal took 2.5 days. There was some disruption, again, caused by R&H's applications to amend and introduce new issues. And the amendment application, the interlocutory applications, took 1.5 days. There was a day on costs, and you may remember that there is another separate matter that's come before this court, sometimes called G3. R&H brought another action against the former trustees, which was struck out as an abuse of process. R&H appealing against the Guernsey Court of Appeal's decision to strike them out. And that, in the Court of Appeal, that abuse of process hearing took 2 days. Yes. So one's got 11 days of Court of Appeal hearing time, and it gives you some idea of the complexity of some of the issues. But the difficult ones are Article 32 and unjust enrichment.
Yes. Thank you. Yes. Mr. McQuaid.
The board indicated there were 4 questions in which the board would wish to have assistance today. I think I can be relatively brief on most of them. We endorse a lot of what Mr. Tolb has said on behalf of the BVI companies. As to the first question of whether the appellants sought a finding of gross negligence in their oral presentation before the Court of Appeal, I think was the actual question posed, or argued only for a retrial. We don't dispute, my lords, that in the notice of appeal, a case was sought to be maintained before the Court of Appeal that there should be a finding of gross negligence. But what is apparent, three points I would make. It is, first of all, it's quite apparent that by the time of its judgment on this part of the appeal on the 10th of August of 2015, and Mr. Taub has taken you to this, it's at bundle 1 at electronic page 339, in the hard copy it's 336, where the Court of Appeal is quite clear as to how it understood the question that had been put to it, and it's expressed fairly clearly in 2 places, and Mr. Taub has shown you both passages, so I won't.
You need to show us.
I need to show you again, but I just want to quote one phrase, which is the phrase that rings out from paragraph 97, at page electronic page 339, hard copy 336, where it's the conclusion urged on the Court of Appeal by R&H was only a retrial would suffice. And indeed, that looked at in the context of the judgment, you can see that in the context of the judgment as a whole, they start from paragraph 47, hard page 323, electronic page 326, to deal in some detail with the gross negligence case. And they direct themselves expressly at the end of 49 to say, the very end of 49, to say we address matters on the basis of the test to be met as that is that of gross negligence, and that's the context in which the Court of Appeal deal with the criticisms of the gross negligence findings, and there's no suggestion in the judgment that the Court of Appeal believed that it had before it an alternative remedy to that of a retrial. Now, that's the first point, my lords. The second point, which I think was also touched on by Mr. Taub, is that it is worth noting that R&H until now have never said in any of their appeal documents that the Court of Appeal erred in failing to consider their alternative case, that there should have been findings of gross negligence in the Court of Appeal. In fact, they have rather instead spent 18 months since their original notice of appeal back in February of 2016 pursuing an appeal on exactly the same basis as their case is recorded in the Court of Appeal judgment. That is to say that there should be a retrial. Now, the parties, you will have noticed, have not been shy in this case at criticising the Court of Appeal when they think they've got something wrong, but that was a criticism that was noticeably absent. And the third and last point on this question, my lords, is that in our submission, Mr. Taub has taken you through a number of the references, but when you look at the transcripts of the Court of Appeal hearings in the round and looked at fairly, in our submission, the Court of Appeal was quite right in its interpretation of the case it was left to deal with. When you ask the question, how was the Court of Appeal led to that understanding, it's been articulated by Mr. Taub. There is, and what we consider to be an important passage also in Supplementary Bundle 1 from the 17th of February, where if one looks in the electronic pagination at 624, it's in the hard copy at 618. One has, I'd like to invite your Lordship's attention to the text at the end of 618, 624, from 4 lines in, but the ultimate conclusion, I submit, is that in relation to large swathes of R&H case, it is not possible for this court to arrive at a safe conclusion as to the proper outcome. That's particularly so in relation to R&H's allegations of gross negligence, and perhaps most singularly, its case that the former trustees were grossly negligent in failing to divest themselves of liabilities to Glenalla and Thorson, and if it be the case in assuming liability to Oscatello at the time of entry to the framework agreement.
Yep. No, I've read to the end of the paragraph.
And I would, in that passage, I'm grateful, my Lord, I would draw attention to the words where the advocate says that he would struggle to steer this court to a specific conclusion and on the gross negligence issues, factual issues, and a retrial may realistically be the only way forward. So and that case of gross negligence is just to deal with one point, failing to divest case is the only remaining case of gross negligence because the case on creating negligence and creation of the liabilities has been abandoned. So one is dealing there with the whole gross negligence case that remains, and R&H are submitting to the Court of Appeal in terms that they would struggle to steer it to a specific conclusion on gross negligence. Mr. Taub has, I think, gone through most of the other references I was going to take you to, so I will not revisit that, and he's quite right about the inconsistency of the position taken by R&H when they were trying to oppose the former trustees' submissions. So we say, looked at in the round, that's quite right. And even if one stands back further, if one can spell out of this some small way in which the position was preserved, at best it can only have been very weakly pursued or preserved by the end, which must, of course, go to your Lordship's discretion whether this should be allowed to be raised now. On the second point about the same materials point, my Lords, the question put is, if we allow the additional possibility of the additional remedy in, is one looking at the same materials as were before the court would be before this board, on the application for a retrial, or do we have to look at additional materials? Now, the first point I'd like to make there, which hasn't received a lot of consideration so far, is that in order to answer that question, you first have to ask what materials will be properly an issue on the retrial appeal, because that's an issue on which R&H, on the one hand, and the former trustees and the BVI companies on the other hand take a very different view. And that's because of the court's case management direction, which your lordships, I'm sure, will be familiar with. Just to go there very quickly, it's in the main bundle, electronic, page 390, hard copy, page 387. And these were some directions that the board gave 12th of April of this year. And it said a number of things in the middle of page 388, electronic 391, in the 6th and 7th paragraphs on that page. And the board said, directed itself to the retrial appeal. And on the, in relation to that, it said that as a matter of strict case management and control by case management over the arguments, that first of all, that all submissions on the retrial appeal should be confined to writing, and secondly, that the board was not minded to permit the parties to dispute the facts underlying the conclusions that the former trustee was not guilty of gross negligence, because the board said that that was a matter of concurrent findings and had been addressed at some length by the Court of Appeal. Now, when those directions were given, my lords, the challenges which were purportedly made in the R&H notices of appeal, and one can see them from the bundle page, electronic page 50, sorry, it starts at 50, it's actually electronic page 70 and hard page 67. This is the unamended form of the notice of appeal. We looked at it somewhere else a moment ago. But at paragraph 6.24, if you have it, there were, at 6.24 B and C, and the sub-paragraphs which follow over the page, there were factual challenges being sought to be made to the gross negligence findings. And those were the passages that we understood that the court's direction was going to say that as a matter of case management, we are not going to permit the parties to dispute these underlying facts. And I would anticipate that the board would be quite surprised in the light of the case management direction to find that in R&H's written case for the retrial appeal, one has about 26 pages where issue is taken challenging underlying facts on this part of the case. And those R&H's written submissions in this regard, they're in the same bundle at 253, and the passage, 253 in the electronic, 250 in the hard version, and the passage where underlying facts are challenged starts at electronic 265, hard 262, and there are 26 pages through to page 291, where there is a challenge made to the facts which founded the no gross negligence finding. Now, R&H asserts in this document that these were not concurrent findings of fact, or they're within an exception to that practice, but well, that's wrong for reasons we explain elsewhere. But in any event, my lords, the direction was that they were not to be permitted to challenge them, and this conduct does seem to denude the direction of any substance.
This sounds a little off the track of the issues in front of us now. It sounds as if you might be laying the ground for some future objection.
Well, my lord, we did, as your lordship may have seen, in our notice of objection to this application, say that actually your lordship should be making a ruling that these passages cannot be relied on. But the reason it is of relevance, my lord, is that if one is comparing what material are we already looking at, what material would we have to look at, the question first arises, what material are we already looking at, and are we allowing challenges to underlying issues of fact pursuant to our case management direction? Well,
as I see it, I mean, either they're allowed to raise that sort of issue on their application for a retrial or they're not, and that's a slightly separate issue from what we're concerned with now.
Well, my lord, the issue is does the inclusion of an application to make a finding of gross negligence involve the consideration of significantly different and more materials? Well, and do you have anything to add to what we've heard?
Let me just very briefly address that directly, my lord. in our submission, it is one thing to ask an appellate court to review a finding of fact for the purpose of asking for a retrial on the basis the appellant says the reason to believe the judgment contains errors which may be attributable to a delay, or this finding may be unsafe, the judge may have misunderstood the evidence. The case should be remitted in order that a trial judge can find the facts and look at all the relevant evidence. In our submission, it's quite another exercise to say to an appellate court, not only can you reject the trial judge's and the findings of fact as being unsafe in the findings of the lower court, but moreover, you as the appellate court can safely proceed to find new facts, and indeed to find new facts and find that they amount to gross negligence. Now, particularly in this case, where you have a serious allegation of gross negligence, and you have what the Court of Appeal rightly described in its judgment at paragraph 111 as a complex factual situation. So those do seem to us, my lord, to be two different exercises, because particularly in a complex case, in the first exercise,
I think we can see the force of, or at least evaluate the force of whatever there is in that submission. I mean, it's a different thing, you're saying.
It's a different thing.
You have to be rather more confident to actually make a positive finding. You have to perhaps look at it in more detail.
Well, and one has to make sure one looks at not only all the relevant evidence that was called in relation to a particular issue, but one may, as Mr. Taub has indicated, have to get into issues that were not addressed by the Court of Appeal or the lower court in their judgments. And so in our submission, it becomes something of a different exercise. Right. To address my Lord Carnworth's point about the unreasonably incurred, and isn't this all covered by the unreasonably incurred appeal? The relevance of Article 26.2 and the unreasonably incurred allegation, its current relevance to the appeals is that it comes up in relation to RNH's appeal on the interpretation and effect of Article 32. And if one looks back to the passages that were debated with Mr. Taub, which I believe I'm just trying to find the position in the bundle where your lordships had it.
224 in the harm copy.
245. I had it somewhere else, but the apologise.
I thought we were dealing with 224 in the hard copy, back of tab 8.
I've got it. I'm very much obliged.
I mean, we have covered this point.
We have covered the point, but I think to add to what Mr. Taub says is that, and it may have come across clearly, but it was no part of that appeal in its current form to dispute the facts underlying the Lieutenant Bailiff's findings that liability was not unreasonably incurred. There was no challenge in the original appeal to the facts underlying that, and what the amendments seek to introduce on page 224 is a challenge to the underlying facts, to say, first of all, recharacterize them as being as making a case of being unreasonably incurred, but also indeed bring in the gross negligence case, which is brought in by the wording in blue, and indeed
I think we can see what it says,
and then find some new facts. It says 6 lines from the end, RNH will invite the Privy Council to find certain facts in the light of certain materials. It's incorporating 6.24, which is, of course, the passage which disputes the facts underlying the gross negligence finding, and it incorporates it expressly. So those facts are not already in dispute, and they would be brought into dispute. And finally, on your questions 3 and 4, would oral submissions be required? Well, we would suggest not, given the previous case management direction of the court, my lords. If there were to be oral submissions allowed in this area of the case, in our submission it would quite seriously jeopardise the hearings for later this month, because Mr. Taub has given you a pretty strong idea that there's a lot on that agenda already. There are 8 appeals, I think, that we're involved in. There is a 9th, Guernsey 3, all of which are up for oral submissions. Some of those issues are quite difficult. And the idea that one could easily accommodate this appeal on the facts seems to us to be something of a non-starter, given the times that this took below. And of course, if this is going to prejudice the hearing date, then that would be a serious prejudice in our submission and would be a reason to refuse the amendment if that were its consequence. My Lords, it may be there's little else I can add to what Mr. Talbot said.
Thank you. Yes. Lord Goldsmith. Do you want to reply?
My Lords, I think there are 5 points I want to make in response to reply, if your Lordships will permit, but I'll be brief. Many of the points that have been made, I have to say, we do fundamentally disagree with as to what took place and to what was an issue. But I'm not attempting to argue the appeal now. This is simply an application for permission to amend. Just one factor to just set the framework for this, because I don't think it's come across. It's undoubted that there are 2 particular problems, at least 2 particular problems about the learned Lieutenant Bailiff's judgment. One is the length of time it took to deliver, 18 months, and as your Lordships know, our case is that has affected the validity of parts of the judgment at least. And secondly, that it's wrong to say that there were not findings of error already by the Court of Appeal. Your Lordships have heard, for example, about the question whether it would be necessary to look at whether dealing with these loans would have been advantageous or disadvantageous to the lender counting. Actually, the Court of Appeal recognised that Sir John Chadwick had got that wrong. That's at paragraph 116 of their judgment, where they recognised that he was wrong to think that including these loans would have been advantageous to counting. Your Lordship see it, paragraph 116, which is page 340 of the hard volume. As to the second, which does appear to be the case, the fact that including the loans would arguably be advantageous to counting is only part of the picture, the rest involving an assessment of the solvency of the various group companies. So there's a point that Sir John Chadwick had got it wrong, and it's important because of the discussion that your Lordships have already heard as to the significance of that question. My Lords, the 5 points I want to make are these. Firstly, an attempt has been made, I think, by my learned opponents to argue that we abandoned in the Court of Appeal below the argument that there should be a reversal of the findings. To put it shortly, though, Mr. Taub admitted, and I quote his words, that we did not haul up the white flag. Advocate Swan did not do that. It was never abandoned. And if the argument wasn't abandoned, then simply saying, well, he found himself at stages arguing strongly that if points made by Advocate Wessels were finding favour with the court, that just indicated that there needed to be a retrial, doesn't undermine that proposition. He needs to show that we'd actually abandoned this argument to justify the stance that they're taking, and he cannot do that. I took your Lordships to some of the references in the argument, including the reply of Advocate Swan, which my Lord Mans referred to again, where quite plainly he's not abandoning the argument. He's recognising that the court might decide against it, but he's not abandoning it. And nor did the court itself recognise, the Court of Appeal itself, as we read their judgment, that it had not been argued that they should reverse the findings. I have in mind, I've got in mind paragraph 98. Right. The second point I wanted to make was in relation to the potential addition of argument or evidence, I think argument in relation to R20 and Kirkland and Ellis. My Lords, it's not the case that the original trustees relied upon some investment advisor, still less on R20 or on solicitors, to do what they did. The evidence before the court was that the problem issue, which was the problem that the loans, what was described as the loans problem, that the loans remained in place in the structure that was being created, was never squarely raised with either Kirkland and Ellis or R20. The high point of the former trustees' case is that there was an email from one of the former trustees' officers, Miss Lydia Bleasdale, to Mr. Aaron Brown of R20. But his evidence, because he was examined on this, was that the first time he appreciated that there were loans from Oscatello subsidiaries to the TDT trustee was in December 2008. And the reference in Miss Bleasdale's email a year before had not alerted him to the issue. Now, he was cross-examined at trial whether he should have appreciated the nature of the issue. But culpability, if any, on the part of R20s wouldn't exonerate the former trustees. They were the ones that made the decisions. Mr. Tabb, I think, was trying to persuade your lordships that the argument that they have is a slam dunk. It plainly isn't. It was examined, and the evidence did not support what he would now like it to have supported.
But will we have to look at all that evidence in order to... Will we not have to look at all that evidence in order...
It's something that the court can therefore deal with if this point not having been...
Lord Goldsmith,
Yes.
Lord Hodge has a point.
But whether or not there is weight in the R20 or Kirkland and Ellis defence is something that we would have to look at in detail without the benefit of any findings by either the trial judge or the Guernsey Court of Appeal. Is that right?
But, my lords, the evidence that's relevant is in a very, very short compass. I've effectively told you what it is already. So it would not add, in our submission, really much at all to this appeal.
I see. Thank you.
Right, next
My
point.
third point is one of those areas where there is a disagreement between us and my learned friends. There's a disagreement between my learned friends and us as to whether we are raising the issue of unreasonably incurred in this appeal. We are very clear that we are, and at some point on the appeal, your lordships will need to resolve that. But we're very clear that we are. Therefore, as I submitted in opening, that all the same issues which arise on the gross negligence will need to be examined in relation to the reasonably incurred argument. My next point is allegations that points have not been pleaded. I'm loath to take up time on this, but essentially the point comes down in broad measure to this. We did say that Kauting would have consented. That was a clear issue, and evidence was called about that, some of which the learned judge didn't refer to. That's part of our criticism. But moving on from that, we say they would have consented. So that argument has clearly been pleaded and has been an issue at all stages. I think what's being said simply is that we didn't clearly plead that it would have been advantageous to Kauting to have agreed. And that's the point that I've just shown your lordship in the Court of Appeal's judgment, that actually it would have been advantageous, and Sir John Chadwick misunderstood, I'm afraid, the difference between liabilities and assets in this context. But it's quite wrong in our submission to say this wasn't pleaded. It was plainly an issue that was examined in full. My Lords, just concluding, subject to any questions your Lordships have, it's important to understand that at the hearing below, there were three possible answers to the appeal that was being put forward. One possible answer was that the findings were in fact safe, notwithstanding the errors, notwithstanding the delay. And in those circumstances, the appeals could be dismissed. Another was that it was clear on the evidence that the correct conclusion was the opposite of what was found, namely that there was gross negligence. And the third was that it wasn't possible to conclude one way or another, and therefore the matter would have to be sent for retrial. In arguing, as Advocate Swan did, that you couldn't take the first line, you couldn't say it was safe, of course he would have argued and explained why there were issues which would need to have been resolved in the original trustee's favour to reach that conclusion. But perhaps the acid test of whether or not Advocate Swan believed that he'd abandoned the argument for a reversal of the findings is in the fact that he also, though he's not present today, has signed the written case and has signed the notice of appeal. So, my Lords, unless there's any other question on which we can assist your Lordships, we respectfully invite you to allow the application to amend.
Can you remind me or identify your fifth point? I only got 4 points.
Yes. Or was that what you've just said, is that the fifth? You said there were 5 points.
I think it was the signature of Advocate Swan.
Is the signature of Advocate Swan the fifth?
I'm not strong on numbers, my Lords, obviously.
I noted it as a fifth point.
Right, all right.
Was the point I made about the possibilities that there were before the court.
Yes,
thank you.
Either to say it was safe.
Right. Thank you very much, Lord Goldsmith. Should we go out?
Yes.
Yes. The panel will take a moment just to consider where it's got to, and I assume there's nothing that else that follows from what Lord Goldsmith said. We'll retire. Yeah, we'll come back. We're grateful to Council. We're grateful to Council for their relatively succinct submissions. We see that this is a complex matter. We accept that there was no technical abandonment of the point. Indeed, I think that is common ground. But the question whether the court should have made a finding of gross negligence is not one which has been raised hitherto, hence the present applications to raise it. We've considered whether it would cover new material or would involve new material. On one view, it could be said simply to relate to the remedy, but what remedy is granted, and particularly whether the remedy is by way of a new trial or is by way of a positive finding, it depends upon which of those alternatives one is considering. We accept the proposition that it necessarily involves a deeper investigation to make a finding, a positive finding, and having heard the submissions, we are reasonably confident that the amendment would involve an expansion of issues, an expansion of the material which would have to be looked at. The amendment comes very late indeed, without a very adequate explanation, and we think that there is potential prejudice to the preparation and to the hearing date. And in the circumstances, we have come to the conclusion that we should refuse the application to amend. I think any matters relating to costs can be either dealt with in writing or else simply adjourned to the main appeal.
Would it make sense, my Lord, for it to be adjourned to the end of the appeal rather than to have... There's an awful lot of writing to be done to comply with the timetable.
I think it would make sense.
Well, much obliged.
We're grateful to Lord Goldsmith. We're grateful to counsel here and to those who prepared the papers.